Welcome to Supreme Myths. I'm very excited today to have Professor Chris Green as my guest. I'm going to call Chris because we're friends, even though we disagree on most things. Chris is not only is he a professor of law at the University of Mississippi, he is the H.L.A. Hart Scholar in Law and Philosophy, which is one of the best chair names of any chair you could have, because H.L.A. Hart was, of course, he was who he was. Chris went to Princeton University and then Yale Law School, and then he received and worked for a PhD at the University of Notre Dame. That university's been in the news the last couple of days. We may talk about that a little bit. He is the author of Equal Citizenship, Civil Rights, and the Constitution, the Original Sense of the Privileges or Immunities Clause, an incredibly important book published in 2015. He is the co-author of a 6-volume federal constitutional law textbook, which is probably one of the main textbooks on the 14th Amendment. He did, after law school, clerk for Judge Barksdale of the U.S. Court of Appeals for the Fifth Circuit, and he is my friend. Welcome, Chris.
Thanks for having me.
My pleasure. We're going to get into a lot of things today, but I just left watching the hearings that have been going on this week in the news of Judge Amy Coney Barrett. And I do want to ask you a very open-ended first question that was raised just an hour ago or so in this hearing. And it's going to sound really dumb. The audience for this podcast is mostly, I think, lawyers and law professors, but there are lay people who watch this because I do a lot of radio. So I want to make this accessible to everybody. Do judges interpret or make the law, Chris?
Do judges. So do they interpret or make the law?
When they're deciding legal questions.
Yeah. So two big issues in just interpreting your question there are words do and thee. Okay. So do they depart from the correct readings of the Constitution? Sure, lots of the times, many times every year. All of them, all 9 of them, depart from the Constitution when they decide cases. What they produce, I think, it's sensible to call it law, even when it's made up. So in that sense, they make law. Okay. Do they make the law? No, they don't make the
we'll
law
get to that.
in the sense
wait.
of
I promise we'll get to that.
Entirely constituting the law. Okay.
We'll get to that.
They make law in a certain sense. They make in a certain sense, law in a certain sense. I'll say that.
Yeah, and the background for that is Chris and I have disagreed in the past over kind of a philosophical question, which is why can't Georgia prohibit all abortions, or Chicago? Illinois.
So why can't is a different question. Why don't they? Okay, but you want to be really clear.
Say that again, Chris. I'm sorry. Say that again.
So there's one question: why doesn't Georgia pass a law prohibiting all abortions? And then there's a different question: why can't they, or why shouldn't they? Okay, those are 3 separate questions: do, can, and should. So you want to be careful about slipping from one to the other.
What is obvious already in the first 3 minutes of this podcast is Chris is a rigid textualist, and that's good.
I try to be careful, try to slow down, get into first gear. I recently bought a car. I realized you can't buy a manual transmission car anymore. So you can't. So when you say soon kids are not going to be able to understand what we mean by going into first gear. But cars used to have this thing called first gear where you're really slowly. And that's frequently the gear that I want to be in, unfortunately.
Chris, how old are you?
I turned 48 last weekend.
Okay, so I'm 62, so I have 14. So when you say kids, we have different definition of kids. But I agree with you. That's fun. I want to go back for a minute, though.
So let's we can talk about Georgia and abortion if you like.
No, I want to go back before that. Okay. I want to go back to my original question because we're both originalists.
Oh, good. Yeah.
I want to talk about why all hearings, Kagan's, Sotomayor's, Roberts, Alito's, this one, all hearings. Let's leave Bork out. We're not going to include Bork in this. But since Bork, why is it, Chris, do you think that we have to? Because I want to make this topical. Why is it that the Senate has to pretend that judges interpret the law, don't make the law? Even the liberal judges could have come out today and said to Judge Barrett, "Come on, Judge Barrett, are you kidding me? You had all this discretion in your Second Amendment case. You dissented. You had discretion not to dissent. You could have joined the majority. It was an open space, and what you were doing there was really creating new law, not interpreting old law. And that's not bad. It's just the truth." Why can't they say that?
Well, part of the thing is they do. I mean, you asked whether they interpret or make the law. They do both. Okay, so because they do in fact interpret the Constitution, it's one of these hearings. These moments are one of the few times when you get to see your representatives talking about the nature of the Constitution itself, and that is distinct from what courts do. So if you want to talk about what courts do, there's lots of places to do that. When the courts make decisions is really the time when that kind of conversation is most appropriate. So the end of June, we get lots of conversation about what just happened. But these hearings, I think it's a good thing about them that they do talk about the Constitution itself. Well, you hear the word oath quite a lot. You hear, I take an oath to support this Constitution. I've looked for, just canvassed American political culture for statements like that. They happen a lot at confirmation hearings. So I think to the extent that they do remind us that one of the things that courts do, maybe not the only thing. So sometimes they make it up, but they also do interpret the law that exists. They interpret the Constitution, and that exists over and above what the Supreme Court does. And that's an important thing to remind us.
Let's drill down on that point. Let's really drill down.
Yeah.
So the Seventh Circuit gets a case where a state prohibits all felons from owning guns. And they have to decide if that's constitutional or if it's overbroad. Everybody agrees the state can prohibit dangerous felons from owning guns. I think everybody agrees on that.
Heller certainly says that. Okay,
Heller says all felons.
Well, it says nothing in this opinion should be read to cast doubt on long-standing prohibitions, such as. And then it lists such as laws keeping guns out of the hands of
felons not
or mentally ill. So, but then the question is, reading that sentence from Heller, is the long-standing doing work in limiting the scope of what comes later? Okay. So that's the issue I think that the Seventh Circuit had to deal with. But I don't want to talk about Tanner specifically.
I'll concede that for sake of argument. There's another way to read that passage, but I'll concede that.
Oh yeah. No, but that's just. I think that's how that's one way to read it, and that makes the lower court's job figuring out what long-standing what prohibitions are in fact long-standing.
Well, no. Remember, we have a state law here. Passed legitimately through all the correct mechanisms. So the judge's job is to decide, does the Constitution prohibit this law? And then
but remember, the Seventh Circuit's job is to decide what Heller means.
Yes, but except Judge Barrett said,
and with the Constitution as well. But bound by Heller.
Hold on, Judge Barrett effectively said that paragraph in Heller doesn't bind us. It was dicta.
I promise not to comment on Judge Barrett for a while, so I can't comment specifically on.
I'm just telling you what she wrote. I'm just telling you what she wrote in the opinion. She said prior panels of this court have held that paragraph as dicta, so we're not bound by it. Let's go back to the drilling for a minute. A well-regulated militia being necessary to the security of a free state, the right to keep and bear arms shall not be infringed. Does that constitutional provision, as interpreted by the Supreme Court and prior Seventh Circuit opinions, does it lead to what result does it lead when a state says all felons are disarmed from owning guns? And you then, I think that what a judge does at that point is interpret text, history, precedent, and come up with the best answer. And you call that interpretation.
One of the things they do, right.
Okay.
So,
Judge Paul,
United States, yeah, but one of the ways you can do
I didn't finish my thought. Let me finish my thought, then I'll ask a question and let you go. Retired Judge Posner and I take the position that when you have an issue like that, where you have to interpret text from 1789, where you have to interpret maybe cases, old cases, where it's clearly an open space the court has not resolved, Supreme Court has not resolved, where the judge has discretion, what most people call interpreting the law, retired Judge Posner and I call making and creating the law. Now you tell me why I'm wrong.
Okay, so again, I got to correct your characterization of my own view. So what I think we do, I think you got to look at United States versus Fischer. So I encourage people to read United States versus Fischer from 1807. Chief Justice Marshall there, speaking for unanimous court, says, if you've got policy concerns about an interpretation and you say, wow, interpretation A would be really a bad idea, okay, roughly, that gives you some reason to think that the provision actually doesn't mean that, okay? But what Fischer says is you can look at pragmatic considerations, how, whether something would be a really bad idea. So you have this line in Texas versus White, the Constitution is not a suicide pact. I think that's where it comes in. Right. So you've got these intuitions about, well, it would be, letting dangerous criminals have guns would be a really bad idea. It seems just a priori, again, before you look at the evidence, a priori, pretty unlikely that the Second Amendment would let.
You're the first guest to use a Latin phrase.
Okay.
Chris, hold on. Chris.
A Posner would just say,
Chris,
okay,
pause.
Okay.
I just want to point out you're the first guest of 13 episodes to use a Latin phrase, and I appreciate that. Go ahead.
Okay.
Sorry, didn't mean to interrupt.
So anyway, so you've got intuitions about what would be good gun policy, and you go back to the founding. The way I would do it, you've got Heller, and then you've got all the undecided stuff, where you might have an opportunity as a lower court judge to fill in the blanks. When you're filling in the blanks, if you're genuinely if your job description includes constitutional interpretation, okay, then you go to the actual Constitution, which is an expression of meaning historically situated at the time of the adoption of the provision, okay, and you go to that and you figure out what that expressed in context, okay, and you've got lots of policy issues that are going to influence how you read that, as Fischer says. James Madison in 1791, he says, you try the interpretation by the consequences. Okay. Now, both Madison in 1791 and Marshall in 1807 say, of course, if the provision is clear, even if it's a bad idea, you got to enforce it. Okay. So if the Second Amendment said all citizens, including those with dangerous felony convictions, have the right to keep and bear arms for the defense of themselves. Okay, if it said something that clear, obviously you couldn't interpret it, even though, wow, that would probably be a really bad idea. Okay, so I gather that Judge Posner, he says, well, if it's a really bad idea and it's a really old provision that you really think we should just forget about, just forget about it. Okay, roughly. Justice Breyer, his dissent in Heller looks into these things. He's like, let's look at all these studies. Okay, let's conduct the largest meta study of gun violence studies and determine that you get it best to agnosticism. Gun rights would be possibly really dangerous. So Breyer says, let's be agnostic about it. Let's let states, keep people who, commit whatever minor felonies or, fraud-related felonies from owning guns, okay? But I would think a big part of what you're doing is, so in the Heller interpreting part of this, they say longstanding, and if you interpret longstanding, or if you interpret the Second Amendment to have a tacit exception only for longstanding prohibitions, then you have to go back and do the history and figure out which prohibitions are in fact longstanding, and people who lie to the government about foot implants, there's not a long tradition of keeping people like them from having guns. So that's not a longstanding prohibition. That's one way you could see the evidence, I think.
Well, but I think Scalia in that paragraph, all he was saying was nothing we're saying here casts doubts on these things. He didn't say.
So we're not saying anything either way about those kind of prohibitions, right?
Well, the key point I'm making, Chris, is we're not saying anything about a lot of things like assault weapons, whatever. But you didn't answer my question, or we didn't get to the heart of my.
Let's get to your question, okay?
We didn't drill down to my question here. So Judge Barrett and the two. This is just a written opinion. You don't say that, Judge Barrett. Judge Barrett's written opinion.
I don't even say anything about the opinion itself. So go ahead.
You can't say anything about the opinion itself?
Well, I don't know. The rules are mushy, but I'm trying to stay away. So.
Well, okay, pause.
You'll find out soon enough.
I kind of have to ask you why this cone of silence.
Yeah. I'm sorry?
Why this cone of silence about Judge Barrett?
I can't tell you. You'll find out probably within a day why I have a cone of silence.
Well, this will be
it's exciting. It's very exciting.
Are you testifying?
I can't talk about why I can't talk about it.
Are you testifying? All right. But this won't get aired until Friday probably, so we'll know. Okay. All right. So, but we haven't, as Chris and I tend to do, we both of us tangent. I want to really focus on this question for whoever's watching this. And I know some sophisticated law professors may say this is silly, but it's not silly. This is not silly.
Not silly.
When a judge has to decide, hypothetical judge, does the second, now we have a different circuit. We're in the Third Circuit with the judge, so Judge Barrett's not involved. Third Circuit, Fourth Circuit, not the Third.
Like being on the Fifth Circuit.
No. Let's be neutral here. Let's say the Second Circuit. The Second Circuit has to decide whether New York can ban all felons from owning guns. And the text is unclear. Yes, just a couple yes or no answers. The text is unclear on this issue.
It might be initially unclear when you first look at it.
Okay.
Clarity can change over time. This is an important thing that Thayer got wrong.
What can change over time?
Clarity.
Okay, fair enough.
Something might be initially unclear.
Okay.
But you can learn more about the context and it can become clear.
Okay. But I think we're going to agree that the text is unclear whether you look at it from 1789 or today about felons, because we're going to find that they didn't know about AK-47s, and that could have changed their mind. But I don't want to get that right now.
I don't think we would necessarily agree about whether at the end of the day it would remain unclear. So I don't think you can just assume that after extensive historical investigation it will remain unclear.
You're right. We disagree about that.
Okay.
Can we then try to find a place of agreement?
We could try.
People with different priors will view the relevant history probably in different ways.
Absolutely. And this is Fischer. I mean, Fischer makes it very clear that how you read history is going to turn on your own views about what would be a crazy thing to say. So if the audio suddenly goes out and it seems like you're speaking French, but it doesn't match your lips, I'll think, well, I guess there's some sort of weird internet glitch that we're getting some other line, okay? But, if you suddenly, start saying things that, Posner's approach was wrong or something, but it matches your lips, then I'm going to think, well, I don't know. Is this the kind of thing Eric would say? I don't know. What Fischer says, and I think this is exactly right, and it's very similar to what you just said, your prior beliefs about what would be a crazy thing to say influence your assessment of what would be likely to be said, okay? Because you have this initial assumption that, well, other things being equal, okay, and in lots of cases they're not equal, other things being equal, the framers were kind of like me in these relevant respects, okay? They did some terrible things, and, anytime they start talking about slavery, you're like, I don't know. We might have really, really, really different views. And so when you're interpreting, Article 4, Section 2, Clause 3, knowing that they really were very soft on slavery is important in interpreting what those words mean. the fugitive slave provision. But yeah, your priors are going to influence you.
Okay.
No question about that.
So especially if, and I hope, I don't want to discuss this. I'm just going to say it. If you don't agree, I can't. I mean, especially if you have life tenure unreviewable power. That is likely to make.
I am a firm believer in the crooked timber of humanity, and self-aggrandizement. Self-aggrandizement happens all the time, and people live a lot longer today than they used to, and things that used to be a good idea are now dreadfully bad ideas. Okay, I mean, I'm with you on an awful lot of that. Yeah.
So I want to get to. We're going to get to originalism core in a minute, but circling back to my question, is the job that a judge has to do, any judge, in trying to decide whether the Second Amendment prohibits a state from barring all felons as opposed to just violent felons. Retired Judge Posner and I think that issue, when you talk about having to interpret the text by going back to the original sources and then prior decisions and then history and then traditions, right? At the end of the day, what you call interpretation, or what most people call interpretation, what all the senators call interpretation, in public anyway, is so close to creation as to be indistinguishable because, at least at the Supreme Court level, let's forget the lower court for a minute, they're not bound by their own cases either. So they have, in effect, limitless discretion when it comes to interpreting all the tools you want them to interpret. I don't mean any result is possible. I mean on the binary question, can states outlaw all felons from owning guns? Yes or no, just yes or no. The answer to that is creation, not interpretation. Tell me why I'm wrong.
They can get away with a lot, okay? But, when they say things that are wrong, they get called out on them. And they have a constituency, even though it's highly unlikely that they're ever going to be impeached or removed. They care about their reputations. And people like you and me can influence their reputations. And we
I don't think so, but okay. Maybe you.
I mean, I don't know about people like, people much higher up in the food chain can influence people's reputations. And when they look at details and they say, wait a minute, you look at this, you cite this page number of a brief and you look at the brief and you look at the data, it says something contrary to what you cite it for. Okay, this is something I've done. And I don't know how many people paid attention, but this is the kind of thing that if that guy says something in the future about a fact and cites a brief, I'm going to be skeptical. Okay, and I'm going to tell other people to be skeptical. And anybody who looks up that page number, that citation, is going to, just not trust that judge on matters of detail.
Okay,
that's if you get the question of just like, is traditional disarmament of dangerous of felons, does that extend to all felons or merely the dangerous ones? If that history is wrong, you might not be able to tell immediately. You might not be able to tell in 5 years or 10 years. But I think you give it 7 or 8 good dissertations, and the truth, I think, will ultimately out. That's the hammer we have. It's a very it's not a very big hammer. It's not doesn't move very quickly. But shaming sanctions are basically what we try to impose, and reputational costs. Imposing reputational costs on people who commit intellectual errors is roughly the only sanction that we have, and it's a weak sanction, but it is a sanction.
I am very confident that that Supreme Court justices do not care about intellectual errors. They do care what people think of them because they're human. And some might care what the New York Times think. Some might care what the Federalist Society thinks. Some might think what other judges think. They obviously care.
They care what people come up to cocktail parties and say.
Okay.
So like Scalia's Raich concurrence. He had a bunch of people come up to him at like cocktail parties and say like, "What were you smoking? Were you using some of the material from the case?"
For those listening, wait, Chris, stop. Hold on. For those listening, you keep assuming Raich was about whether Congress could outlaw the possession of marijuana. People might know that.
Yeah,
and
Raich is
Scalia,
virtues.
and Scalia said they could. But hold on. Shelby County involves not only the concoction of a principle of equal state sovereignty that's not in the text and counter to the 13th, 14th, and 15th Amendments, whatever its connection to the original Constitution, but also, I don't think that's debatable, but that's not the point I want to make.
It's debatable. I don't know.
It's not debatable.
I don't have a particular. I'm not carrying water for Shelby County a whole lot.
The 13th and 14th Amendments could not have given rise to a principle of equal state sovereignty. But leaving that, that's not what I want to talk about.
Yeah, there's background stuff. The word proper has equality connotations, I think.
In 1965, now this what I'm about to say is a fact. In Katzenbach in 1965, the court rejected an equal state sovereignty argument emphatically and with clarity. Justice Roberts never overturned that. He distorted it with ellipses to say that there is a principle of equal state sovereignty, which there is when states come into the Union, but not when they're already in the Union. That's what the 65 case said. He deleted the part about when they come into the Union. It was shameful. Let me finish. Justice O'Connor in Adirondack, in a big affirmative action case, called a previous affirmative action case, Metro Broadcasting, a departure, a significant departure. That's demonstrably false and wrong. We can go further back. In Younger versus Harris, a famous abstention case in federal courts, Justice Black lied about a previous precedent, the Dombrowski case, and said it meant something that it didn't mean something that it did mean. And then there were 50 other examples. So I agree with you.
There's thousands. There's a lot more than just 50.
Okay, good. Chris and I agree there are thousands of examples of demonstrably false statements. Well, that's a good tagline. Chris Green and Eric Siegel agree there are thousands of demonstrably false statements in Supreme Court opinions. That's good. They don't care about that. They do care about results. They do care about how their reputation is affected by results. I don't think they care that their reasoning was sloppy. I want to talk about originalism. Define.
Okay, I think they care about that. I think they care about this a little bit. When there's thousands of people saying the same thing.
There's no evidence of that. Justice Kennedy was shameless, right, about doctrine. There's no evidence that he cared. Right.
Kennedy's the one with the egregious error in the citation of the brief. He didn't respond to counter arguments. Both he and Rehnquist, I think, their failure to respond to counter arguments is just really bad. When I teach these cases, I show them Kennedy's stuff, I show them Rehnquist's stuff, and I look at the dissent, and you're like, well, where's the response to this dissent? And there's like, oh, they just didn't feel like they had to do that. Don't be like that. Okay. Yeah, and you look at Stevens and Scalia going back and forth in the footnotes, and I said that's how to be. I think, Kuhn talks about paradigm shifts happening in intergenerational, like one generation finds itself unable to convince the next generation that this is the way to do it. I think, our job as professors, and, again, people higher up in the food chain are much more important about this, but when they point to opinions and say, don't do it that way, that has an effect. And, people who grow up having these ellipses that are screwed up. There's some stuff in Bernie that is just, oh, my word, I can't believe that nobody pointed this out.
Right.
If you grow up and you have professors who say, look at that, don't do that. You get more careful judges in the next generation. I think it has an effect.
The best example.
But let's go on to other stuff.
I think we'll agree on this. I know people want us to disagree, but I think we'll agree on this. I think one of the most pernicious examples of that ever is Romer, which is a case where the Supreme Court overturned a constitutional amendment in Colorado that said no more special protections for gays and lesbians. And Justice Scalia and the state of Colorado both argued vehemently that a previous case, Bowers versus Hardwick, was very relevant to this case. In fact, decided this case. Whether that's true or not, I don't care. But it was all in Scalia's dissent. It was all in the briefs. And Kennedy doesn't mention Bowers once.
And Kennedy's like lighting himself on fire trying to get Kennedy to respond to it.
Scalia is, yeah.
Scalia is. Kennedy. Scalia is. And I think it's a terrible thing not to respond to counter argument. I had one of my students. What he did is he went through Westlaw to see which dissents had things that were marked in Westlaw as like, majorly discussed or, examined by, and precedents that were mentioned by a dissent and then not mentioned by the majority, and seeing which justices do it the most. And I had this hunch that it was going to be Kennedy coming out on top, and he did. I probably shouldn't describe it without remembering the details better than I do, but yeah, that's the kind of thing that happened a lot, and Rehnquist did it a lot too.
I think Romer violated the rule of law. I think. Imagine talking to your client. Imagine talking to your. Imagine the client. Imagine in this case it's a state, but imagine the general count, the attorney general for Colorado, and the client thinks that Romer is going to be the main part of this discussion, and the dissent says it should be, and the briefs say it should be, and it's completely ignored. It's not even. It's crazy. Okay.
Just let me add this one little bit about Romer. Is that this is 96. 7 years later, of course, Kennedy overrules Bowers in Lawrence, and what is his rationale? His rationale is, in Casey versus Planned Parenthood, we have this, at the heart of liberty is the right to define your own concept of existence. But Casey itself, in 92, when they asked whether the foundations of Roe from 73 had been eroded in the past 19 years, didn't say anything about Bowers. Okay, so if you think Bowers in 86 and Casey in 1992 are in conflict, Casey did not think that they were in conflict. So then when he comes back in Lawrence and says, what's our reason for overruling Bowers? Casey, which said there had been no erosion of the, that kind of thing happens.
I often point to Romer as one of the hundreds of cases that suggest the court is not a court, because courts deal with counter arguments.
Yeah, they're still a court. They're just doing it really bad, really poorly. I'll say.
So I've had other people say to me, Eric, it's not that the court is not a court; that's a terrible court.
Yeah, that's what I'm saying. Yeah.
At some point, those merge. All right, we've gotten
it's a terrible court. It's terrible things.
So I have a couple yes/no questions about originalism, and then I'll let you speak. Okay? Is originalism an it or they?
I don't even know what it means. It's a view. I would say it's
a family of theories.
It's a view that has. It's a family of views, I guess. So saying it's a view is a little odd. It's not. I wouldn't define it in terms of a person.
No, I'm not. Just saying there are many different forms of originalism.
Yes? Right. I would define it chiefly in terms of propositions rather than people. So saying it's a they is I think trouble.
I didn't mean they as people. I'm sorry. I meant they as there were a lot of different.
There's different theories. Yes, absolutely.
Okay, and we would agree that at least on paper, Judge Bork's and Raoul Berger's the 1970s originalism is very different than Scalia's and Randy Barnett's and yours and other people's today.
In certain ways. So, Berger was very clear that he refused to distinguish meaning from application. Bork very clearly distinguished.
You're going way too fast.
Okay.
The audience.
But Berger and Bork are different. They just say 1970s originals. Again, defining it in terms of people, I think, is itself too quick.
Okay. So the dominant part of originalism in the 1970s was strong judicial deference. A dominant part of originalist theories today doesn't have that component. Is that fair?
Okay, yes. I would really distinguish. I think that's a category mistake to talk about whether originalism includes deference. I would say originalism is a view about what the Constitution. I got to hold up my Constitution.
I knew you were going to hold it up. I knew you were going to hold it up. Go ahead.
Okay, so you have one question, which is, what does it mean to say something is constitutional? So you've got this word, the Constitution. What does it pick out? That's the question that originalism is dealing with. How restrained we should be as judges, or judges should be, or executive branch officers, or legislators, or state officers, just different officers in the system, how restrained they should be in interpreting the Constitution is a separate question. And you can ask that same question with respect to lots of different views about what the constitutional truth maker is. So I would say in the 70s, you had a view about what the Constitution was that was in part motivated by the kind of thing that could be applied in a restrained way. Okay, but distinguishing those two issues allows you to say, well, maybe they were right about what the Constitution is, but wrong about how restrained we should be. I am an advocate of restraint. I think there's a clarity requirement for judicial review, but at the same time, I think you've got to depart from what Raoul Berger said about saying that meaning is the same as application.
Okay. If I asked you to define originalism, how long do you think it would take you? Answer that question first.
I think it would take me about 30 seconds.
Go ahead.
So my originalism. Okay. My originalism is the view that when officers who have taken an oath to support the Constitution interpret the Constitution, when that's part of their job, the thing that renders their statements about the Constitution true or false is the sense originally expressed by the text of the Constitution according to the legal conventions of the time of the adoption of that provision. That's originalism, as I said.
That was very good. So let's apply that definition to the real world, okay, or hypothetical about the real world.
Sure.
A 6'3" incredibly fit and talented woman wants to play football at this is a hypothetical, wants to play football at the University of Georgia. And the University of Georgia says, we're very sorry, we're going to limit our football team to men. And we have a lot of reasons for that, but that's just how it is. And you don't get to try out. We're sorry.
I'm sorry, we're just going to blanket ban on even very tall women. Right.
Well, ban on any women playing football for the University of Georgia.
Right.
Well, let's make it more realistic. You can be a kicker, but you can't be anything else. We're not going to take the chance of you being anything else. She sues and says the state of Georgia, bound by the 14th Amendment, has denied me all kinds of rights under the 4th Amendment to be treated the same as a man trying out for this. And you're a judge, and you have to decide this case. This is real. You have to decide the case.
I'm on the Supreme Court.
Let me finish the hypo, then I'll let you do it.
Okay, but I mean, what court are we talking?
You're a Supreme Court justice.
Okay.
And you said a minute ago that an originalist would look at the sense of what the 14th Amendment is
expressed by the text.
The sense expressed.
It's the judge's job to interpret the Constitution.
Let me finish the question.
Sense expressed by the text.
Let me finish the question. You said a judge's job is to identify and figure out the sense of the relevant constitutional provisions.
Sense expressed by the text, right? Go ahead.
Yeah, and then apply that to our current problem.
If it's the judge's job to interpret the Constitution.
Yeah. Well, in this case, it is because we have a constitutional challenge to the state of Georgia.
Okay, but I mean, remember, there's limits on what questions you address. So
I understand that. What do you mean?
Okay. So you want me to pretend I'm a Justice Green?
You're Justice Green on the Supreme Court. Georgia has barred women from the state of Georgia has barred women from having the same opportunity as men to play football for a very prestigious football school that could lead to many benefits if you're good at it afterwards. Tell me how you analyze the case.
Okay, so one question is, what's the question presented? So has anyone in the case suggested moving anti-discrimination law from the Equal Protection Clause back to where it should be? And the Privileges or Immunities Clause.
Yes. Amicus briefs have raised that. The parties have raised it in a footnote. Yes.
Okay, they're raising a footnote, or maybe, okay, so one thing I would do, so I'm on a court, if you've got 5 of me, I would look at the question presented. I would say, like, let's add a really specific question presented. Let's give it lots of oral argument time. Should we move anti-discrimination doctrine from the Equal Protection Clause, which is about protection from private violence chiefly, back to the Privileges or Immunities Clause, where it should have been, where the initial sex discrimination arguments were in cases like Bradwell.
Okay, stop. You're tangenting on me. All right, fine. It's the privileges
how would I decide it? One question would be, are we bound by U.S. versus Virginia?
Okay, you're not, because you're on the Supreme Court. You're not bound.
Okay.
You're on the Supreme Court.
Well, horizontal stare decisis is not just a river in Egypt.
It's a fiction. Answer my question. How do you go about deciding this?
Okay, so assuming that we raise the question properly, we get lots of briefs, I would go back to, I think Matthew Carpenter's argument in Bradwell from January 1872 is a very, very persuasive explanation of the original sense expressed by the text of the Privileges or Immunities Clause. And what that sense is equality in civil rights for all similarly situated citizens of the United States. That would mean that you have to look at Georgia's professed rationales to see if they're completely bogus.
We're afraid girls will hide their pregnancies from us and get hurt while playing football.
I guess it would depend, how crazy things get at Georgia in terms of hiding pregnancy. I think hiding pregnancies seems like a kind of a weird rationale. I think just generally people getting hurt because there's differences in strength. Yep. Okay, it depends on what
Okay,
what
so
the.
Chris, but that's my point. But wait, hold on. But that's my point.
Yeah, the factual issues. Once you get into the factual issues, the difference between originalism and non-originalism gets a lot smaller.
Oh, I love that.
It doesn't turn into zero, though.
Matt, tag that. I love that.
It's not zero, though.
Say
Smaller,
it again.
but not zero.
I never said it. Say it again.
Once you distinguish meaning from application,
okay,
factual questions
we have
that
like
are
10 minutes, but tell the people what you mean by that.
Okay, so you've got so the sense is equality in, I think, this is what my book argues, is equality in the civil rights of all similarly situated citizens of the United States. Okay, this is what roughly what the dissenters in the slaughterhouse cases say, and Bradwell decided the same day. This is what both Carpenter arguing for Myra Bradwell and Bradley who
Chris,
concurs.
I'm accepting your legal rule. I'm accepting your standard. Go on.
Okay, so then you have this question, this factual question: which citizens are similarly situated to which fellow citizens?
Yes.
So you got this plaintiff who's 6'3", but 6'3". I mean, 6'3" and really strong. How heavy are we talking? How strong? How much can she lift? That kind of question. There's just a bunch of other questions about whether it would be generally safe for a particular person to play football. You have also questions about the costs of having a scheme where you have that kind of question. The methadone case from the 70s, New York Transit, I think, talks about, just because you have an equality requirement doesn't mean you get to always argue for an exception. Okay, so you got a bunch of policy questions relevant to who is similarly situated to whom. Someone like Judge Posner would just say, okay, we'll just decide the policy question. Should we have women football players? The issue that people like Carpenter would look at would be very similar. It would still be limited to civil rights. Okay, so you'd have this additional question, for instance, whether being on a football team is a civil right or some sort of political right. And the argument that it would be some kind of political right would be a little bit weird, okay? But if you're talking about some group of people that is doing official functions on behalf of the university that requires a bunch of strength or something like that, maybe you could make an argument that it would be a political right, even if the limit to civil rights instead of political rights in the 14th Amendment is a bad idea. I would say we're bound by privileges of citizens, which means civil rights, not political rights.
So
does that help at all?
Well, I'm not sure. So let's just drill down a little more. So if you think precedent, I don't think precedent matters, but you think it matters a little. So in VMI, I believe Justice Ginsburg, the case was, does the Virginia Military Institute, which is a taxpayer-funded institution that provides enormous benefits to the graduates of that school in the military, can they exclude women? And Justice Ginsburg said, I think she said more or less, as long as there's one qualified woman, just one, to do it, then they have to let her do it.
Genuine physical differences between men and women remain cause for celebration rather than denigration. So if the classification is genuinely based on real physical differences between men and women, you can do it, even under VMI. Ginsburg herself said that. for the court.
Well, I think she also said if one woman can meet VMI standards, then they have to let her in. I think they said that.
Right. She said, but not for denigration. If they're genuine differences, they're cause for celebration, but not for denigration, and not for artificial limits.
Right, but we're clearly denigrating women when we say you can't get into VMI. It's clear. It's obvious. That's an obvious thing.
Yeah, I mean, distinguishing a pedestal from a cage is sometimes tricky.
There's no pedestal there. There's no pedestal there. It's just a cage. Going back to the University of Georgia.
UVA. If they want to have civilized education, I mean, go to UVA. I don't know.
No, you can't go to UVA. No.
Yeah.
The benefits of being an officer in the military, going to VMI and UVA are not the same thing.
But go to West Point. I mean,
let's go back to the University of Georgia for a minute.
Okay.
I think I heard you say, and we may, I think, agree on this more than we think we do. I think I heard you say that if we agree on the legal principle, which in your case was, just let me talk after you say it, but say the sentence. The legal standard governing this case is.
Okay, the legal standard is under the original meaning of the Privileges or Immunities Clause. I think the question is: the legal principle of the Privileges or Immunities Clause is all similarly situated citizens of the United States get the same civil rights.
Okay. And the question whether someone is, I'm not going to argue with you I'm going to concede that should be the legal standard. Now, of course, in the real world, equal protection would be the standard. But in this world, I agree with you.
Here would be a lot like the VMI standard, right?
Now, to determine who is similarly situated and who isn't, I think I heard you say that's not an originalist, or at least originalism and non-originalism will ask that question in a very similar way. There may be some difference, but in a very similar way.
Yeah, probably.
So,
I guess it depends on the non-originalists how they'd ask the question. But good policy regarding women on football teams and whether particular people are similarly situated to other citizens of the United States under the Privileges and Immunities Clause, those are going to be very similar questions. So the difference, as a result, the difference between originalism and non-originalism is smaller than you might think, but it's not zero.
Okay, that's fair. Fair. So, Chris, leaving aside the Second Amendment and the Recess Appointments Clause, leaving aside those two parts of the Constitution, most, if not all, constitutional litigation in the Supreme Court involves freedom of speech, free exercise of religion, establishment of religion, all the stuff in the Fourth through Eighth Amendments about unreasonable searches and seizures, cruel and unusual punishments, double jeopardy, all that, equal protection, due process, privileges or immunities in your world. I think most of us agree on what those provisions, what the original sense of those provisions were. No cruel and unusual punishment. I think we do.
I think there's a lot of disagreement about the original meaning expressed by those texts.
You do or don't?
I think there's a lot of disagreement.
Well, but I
think the Supreme Court's approach to incorporation has been completely wrong.
Don't go there. Don't go there yet.
Right.
We all agree on freedom of speech, Chris. We all agree on freedom of speech. We want freedom of speech. But in any case where someone says their freedom of speech is being violated, then we ask, why is the government doing this? And they're going to have a reason. And then we have to say, is that reason sufficient to abridge your freedom of speech? And let's just take the internet, which raises all kinds of issues about freedom of speech. Any issue, any non-frivolous issue involving the internet, threats on the internet, is there an immediacy requirement to threats on the internet? That is the same thing to me. Let me finish. That's the same thing to me as the kind of factual questions you asked about the University of Georgia's position. Whether lethal injections are cruel and unusual punishments, whether the president can assassinate an American citizen using a drone strike where no Americans are at risk, and so on. All of those questions that involve a government rationale against a principle we largely agree with are going to be decisions that have to be decided in the here and now, not 1789. Yes or no?
No.
Okay.
You're wrong about that.
Go ahead.
Okay, so
by the way, you have
cruel
about
and unusual
you have 3 minutes to tell the world why I'm wrong.
Okay, well, cruel and unusual punishments. There's a lot of back and forth. John Stiniford has a view, and there's a lot of discussion from other folks about what cruel and unusual means. Sam Bray has an excellent article with a wonderful word, hendiatus, about the Eighth Amendment. The First Amendment, you've got Judd Campbell's work, which both you and I like a lot. And there are people who push back on that a little bit. In terms of whether the president has the authority to wage war, I think you look back at the founding, you look at Prakash and Ramsey's stuff on that, it's very clear that the power to declare war is only in Congress. So if the president is, by a war-making act, declaring hostility against a particular group, whether it's by drone strike or by, a cannon or a musket, that's something that is exclusively in the hands of Congress, and you can verify that going to the original history. So to say it's just a question of whether drone strike is bad, no, it's not. It's history.
Pause on the president's power to. I think you said wage war.
Yeah, Prakash and Ramsey are great on this.
I don't think so. And by the way, as a policy matter, I think Obama clearly violated the Constitution when he assassinated, not clearly, but he violated the Constitution when he assassinated an American citizen who was having lunch in Yemen, not on the battlefield, and no court had ever judged this citizen.
Yeah, so when you say as a policy matter it's unconstitutional, I don't even know what that means.
I didn't say that. I didn't say that. I think it's unconstitutional under due process. He can't kill an American citizen not on the battlefield. I don't think you can do that. But leaving all that aside, the reason why Ramsey's work and what you just said doesn't make sense to me is, first of all, the power to declare war, I don't think in and of itself says anything about necessarily what do we do when the missiles are coming. The president can absolutely respond to that in 5 minutes with his own missiles and go on the offensive before Congress declares war. That's absolutely.
Right. So one issue about what the word declare means, you got to go back, and there's a whole bunch of 18th century history that Ramsey and Prakash look at, and they say, look, there's a bunch of places where people talk about war being declared by deed. So it's not an explicit war, a set of words saying we hereby declare war on you, but like they blew up our ship. That is a declaration of war. So you find lots of references to that kind of thing. No, hold on. The fact that another country has declared war on us doesn't answer the question. Wait a minute. Russia sends their ICBMs toward us. Right. So there's a repelling sudden attacks thing. So
where's that? Where's the repelling sudden attacks thing in the Constitution?
Yeah, so there's a distinction between declaring war and waging war.
Yes.
And so, in the convention, I think it's Madison who says, well, we're going to give the power to declare war, which is the power to take us from a state of peace into a state of hostility. We're going to leave that entirely in Congress's hand. But if another nation takes us from a state of peace into a state of hostility, the president can repel sudden attacks. And when the ICBMs are coming, like, whoa, the ICBMs don't get launched by peaceful countries. Looks like we're at war.
Okay,
you can repel a sudden attack. And sudden is going to be a really fact-intensive question.
But of course, no case involving that's ever going to get to any court. But
not time before we got to hit the button. Right.
But there are many hard questions. For example, and then we got to go. This has been great. For example,
we could.
For example, the Taliban starts accumulating what are possible materials for really terrible weapons in Afghanistan, or Iran starts doing that, and we think that Iran's threat to Israel is a threat to us and is very serious. They don't have the weapon yet, but they may get it in 6 months, a year, or 2 years. Can the president unilaterally, without, Congress's assistance or declaration of war, take out that weapon, even at those things building the weapon, even if that means killing innocent Iranians who are just there? Any question involving any of that, to me, which that won't go to court either. But questions like that could. I mean, there are people who challenge the assassination of that American citizen in court after the fact. My point here is the fact that someone in Afghanistan or Yemen can use a cell phone to blow up a bomb in New York City or Los Angeles to kill 100,000 people in an hour. That fact, and the fact that we can take them out with a drone strike with no risk to American lives, are all facts that no one in 1789 could possibly have anticipated, and will go into a judge's calculation about whether this is an unconstitutional war thing or it's not. And that's not originalism, right? I mean, that's just...
It's you take the original sense and you have to add the actual facts. So sudden is the word that Madison uses, and they understood that as technology changes, suddenness calculations are going to be different. I mean, you look at Thomas Babington Macaulay. He has this classic place where he talks about what level of risk justifies self-defense. And obviously, this is going to be a fuzzy boundary, but it's still a boundary which is morally hugely significant. And I think it's basically the same question. How much risk in what time do you have to have something count as sudden? Okay. And that's going to be factually dependent, but it's the application of a general standard that's articulated, I think, it's implicitly articulated in context by the words executive and then giving declare war power to the Congress. That's Ramsey and Prakash's view, and it seems pretty plausible to me.
I agree. So it's my podcast. So before I thank you, I get to have the last word.
That's good.
I'll
come back at you on Twitter anyway.
Yeah, you will. I think most people accept that when we're talking about the universe of Supreme Court litigated constitutional law cases, so I'm talking about the universe of con law cases that get to the Supreme Court, what you call fuzzy boundaries, you just said that, are going to be present in virtually all of those cases. And the differences between originalists and non-originalists will fade away in 95% of the cases. Not all of them. Heller wasn't that. Noel Canning wasn't that. But in most cases, the difference between originalism and non-originalism will fade away, and they'll just decide as a policy matter the contours of those fuzzy boundaries. And I think that's obvious. Just talking about Supreme Court.
I don't know about 95%. It's a lot. It's a lot. There's cases like Reynolds and DeShaney that I think don't involve it.
Okay,
so you said you wanted the last word. I'll let you go. But Reynolds and DeShaney is always my answer to that.
So maybe since 1945 there have been 20 of those cases, but there are hundreds and hundreds of con law cases. So I think most of them have fuzzy. Anything involving unreasonable searches and seizures is going to have fuzzy boundaries. Same thing with criminal punishments. All right, Chris, I really, really appreciate this. Yeah. You're right. I should have considered a two-part thing because we have.
We could go back and do another. We could watch the video and then we've just watched it, and now we just kind of continue the fight and then put it as a two-part thing separated by our ability to watch it.
Your big reveal about why you can't talk about Judge Barrett, I think, will be public by the time this is aired.
I certainly hope so. If it's not, I'll be very embarrassed. But
okay. Well, I think if the big reveal is you will be testifying in favor of her, I think
not in person.
Well, yeah,
not written for. I'm not going to be testifying.
Okay, Chris, thanks a lot. This has been. I want to say that I always learn, and I enjoy our conversations very much.
Yeah, and frankly, I get so many comments from people. I run into people from time to time who say oh, I never comment on your Twitter exchanges with Eric, but I really learn a lot from them. And that's what keeps me going is on Twitter is people who say things like that. And I do think it really is illuminating. It's frustrating, constantly making the same arguments again, but I think it really is helpful for the audience.
For whatever it's worth, I get that too, and I think. Maybe in our little corner of what we do, maybe that affects some people in a positive way. I hope so.
I hope so.
Thank you, Chris.
It's wonderful to be on the show.